and welcome to another episode of Law Unfiltered. I'm Jonathan Mason.
And I'm Sonia Madison. And today I want to talk about Miss Beyonce because she's back in the news. She's typically in the news, but at least for this one, it's another copyright issue. And she's no stranger to this because a lot of her music is sampled by other artists. For example, The Naughty Girl, and I think there was also Crazy in Love had elements from other R&B artists. But this time, her visual album, which I enjoyed, it was really nice for all you Beyonce fans. Please don't cut me later. But she's now being sued by, I think his name is Mr. Matthew Folks, saying that he took her, or she took his, let's say, I guess, short film, it was about 7 minutes, and used that to create her visual album as well as her trailer. So he's arguing
for Lemonade.
Yes, for Lemonade. And so he's arguing that he should be entitled to some copyright infringement. Now, I don't know if you saw both of them, but first, talk about what is it that she is going to have to show and what defenses is she going to be able to have.
Yeah, okay. So there's sort of a test for, like a lot of legal claims, there's a test for copyright infringement. And but before you get to the test, you have to have a copyrightable work. That's sort of a given. Although in this case, it's not that simple because you can have a copyrightable work, but that doesn't mean every element of that work is protectable. So, and we'll probably get into that in a little more detail. So let's say we have the underlying copyrightable work. Well, if you're the plaintiff in an infringement action, then you need to show two things. You need to show that the alleged infringer had access to your work, and then that the work is substantially similar. So there are two things that you have to show, and you have to show both of those, and you can lose your case if you fail to show either one of those. So the burden is on you to show both access and that the works are substantially similar. And substantial similarity, it does get a little complicated, and it also depends on, the type of work. And for example, we had the Blurred Lines decision with Marvin Gaye and Pharrell and Robin Thicke. Well, we as lay people or even as writers of the song are probably not qualified to say whether work is substantially similar, like in a case of music work, and they have to hire experts, in that case musicologists, to come in and analyze the music and the elements and the notes and the spaces and the pauses and give an opinion on whether the works are substantially similar. And there's a similar analysis, although a musical work is different from a visual work, but there still has to be, and again, if you're the plaintiff, then the burden is on you to show those two elements.
Well, in this case, he claims that she had access to the work because he sent it to someone who's a friend of someone. I mean, he kind of went down the line of how she could have gotten access, but essentially through the record label, through various connections in there.
Yeah. Can I kind of tell you a quick access story on one of my clients? He had a song, and a well-known rapper or two collaborated on another song, and he said, "Hey, they stole my song." And I said, "Well, the first thing you want to know is how they get it." So my client was like, "Well, I went to a conference and the rapper was there and I met him and I gave him my song." And I was like, "Okay, well, that's good. Can you prove that?" So yeah, I've got photos. So he literally had a series of photos, and in the first photo, my client was holding a manila envelope in his hand that he said had the CD in it. And then the next photo, the rapper had the manila envelope in his hand, and I was like, man, that's the best evidence of access I've ever seen in my life. Like, it doesn't normally happen like that. So in this case, yeah, he goes through the allegations in pretty much detail on how they got access to it. And then, there was a motion to dismiss filed.
First of all, I want to get into that. So
But I want to say about that, it doesn't seem like they're arguing over access. It seems like they're arguing over substantial similarity.
Which I'd imagine, I guess, from the legal standpoint, I'd imagine that is definitely a little bit more factual. We can it's hard to say after he's gone through these channels to come back and say, well, that should not be substantial for motion to dismiss. Now, maybe for summary judgment when it comes to access, but I'd imagine when it comes to motion for dismissing, it's a little bit harder to dispute whether someone has substantially raised the access argument. I think he did here. But now when he talks to the substantially similar, which is the thing you get into in terms of whether the works are related, he goes through at least 8 or 9 similarities, and he really focuses on the trailer more so than the visual album of Lemonade. And so one, I want to ask you, if he had just articulated 1, or even 2, do you think that would have been enough, or is it very important that you do articulate more than just one aspect of some substantial similarity for a copyright claim?
Well, I think it depends on how important that 1 or 2 aspects are to the underlying work. Again, take music as an example. You might only borrow a couple of seconds from a song, but it could be the most famous, or the hook, or the title of the song. So it's not. So I guess you have to look at it quantitatively and qualitatively. And in this case, it seems like he had a lot of quantitative examples, so he had numerous examples, and I think part of the defense is, you pointed out a lot of alleged common elements, but none of those are really copyrightable elements of your work. They're just kind of like general concepts.
And again, to clarify, when you say copyrightable, that doesn't mean they're not similar.
Okay.
It just means that legally you didn't meet the standard.
It means that they're not protectable, and in copyright law, there's a French term called scène à faire, and a lot of people have lost cases under this doctrine. And basically, what it means is a scene is so intertwined with a type of work that it's not protectable. And I'll give you an example. Like if you had a war movie, and say you had a scene where there was a army battalion coming ashore to attack the enemy. Well, if someone else did another movie and they had a scene on the beach where, an army was also, you can't copyright an advancing army coming onto a beach, because it's just a general concept. So if someone wants to do a war movie, then if someone else copies that same scene from your movie, hey, that looks like my movie.
And you can show access. You still.
It doesn't really. It doesn't. It's in a fair as a defense, though. Because it goes back to, you have to have an underlying copyright, and like I said, just because you have a copyrightable work doesn't mean that everything within that work is copyrighted. So if you have generic scenes, like if you had a sitcom about a family and then they were sitting around having dinner one day, and somebody else has a sitcom and they have similar characters and they're sitting around and having dinner one day, that doesn't mean you can sue, because both things happen in your movie. You have to look beyond that. You have to look at the other creative expressions. You have to look at, well, where did they live? Did the scenery, did the set look exactly like it looked in my movie? Because like the set design, those things are original expressions of my work. So they can't, while I might be able to make another movie about a sitcom about a family, I can't copy, like the name, have the house look exactly alike, have the same theme music or very similar theme music, that type of thing. So
then in this case, okay, so you had 8 or 9 stuff.
Right.
All right, so he starts with, there's rapid flashes of different scenes, which he does have in his movie, and which is also seen in Beyonce's movie, or trailer. And within some of those rapid flashes, one is a picture of garage, which Beyonce also has a picture of garage. Another is a picture of red people who have their eyes that are kind of darkened out. Beyonce has similar images. Another is, there's this grass scene, which Beyonce also has a grass scene. So he goes through at least 8 or 9 similarities. Now, of course, the defense is saying, well, first of all, we didn't put in the same order, but they're also saying you don't have this copyright to grass, so you don't have this copyright to certain visuals. But now, from your perspective, the combination of it all, does that make a difference, or is it each one, if they're not copyright on its own, it doesn't matter if they're collected together?
I think it's too much. It'd be too much of a coincidence to just have all of these elements. So while any one or two may or may not rise to copyright infringement, my feeling is that, look, they clearly saw that work and it was inspiration for that work, and the only question is, are the elements that they copy protectable or not? Because one other thing that the plaintiff talked about is they captured the entire concept and feel of his work. So, and I admit I haven't watched the full 7-minute video to draw my own opinion on that, but just from reading it, I think at this stage of the case where we're on a motion to dismiss, where they haven't even gotten into evidence and discovery, the defendants are just saying the court should dismiss this because they don't even state a claim, then I'm inclined to say that the case should go forward at this point and let them get into some discovery, some more detail, unless they can convince that judge that each one of those 8 or 9 things are not sufficiently original to their work to be protected by copyright.
Which that's, to me, is my question. I mean, even if they can show each one is not sufficient, the fact that all of them are there, does that make a difference? Because as you said, I mean, one of the things he is arguing is the feel and the expression. And I think what he's saying is that we've got these rapid flashes. We've got one woman who is in despair of this broken relationship, and Beyonce is apparently also in despair of this broken relationship. Now, of course, the attorneys are arguing, well, they get back together, whereas it doesn't happen in the first film, but you still get this theme of heartache. And so, you know, if that were to be enough, or if the fact that all of them, even if all of them separately are not copyrightable, the fact that they're all there in the same images, would that be enough to, I guess, to your point, pass the motion to the stage?
I mean, I think so. I mean, but we also have to keep in mind that the standard is not access and exact copy, is access and substantial similarity.
Right.
And there's wiggle room there. There's room for interpretation there. So, although these cases do get dismissed on motions to dismiss, and motions for summary judgment all the time, I mean, I think in close cases, if you're a plaintiff, you just want to survive these motions and have a chance to get to a jury, because most likely if that happens, then, you know, you're probably going to settle. They're probably going to want to settle the case, mm-hmm. because, you know, a jury is really unpredictable, and you never know how much they might grant the plaintiff if they find for the plaintiff. So, but, you know, someone like Beyonce, I mean, she's going to hire the very best counsel. They're going to have a lot of experience in these areas. They're going to be familiar with all, you know, the precedent and the current cases in this area. So, but I guess if you're a defendant, you really don't have much to lose by filing a motion to dismiss, as long as you have a reasonable basis to file it. So it gives you a chance to see, you know, what their arguments are going to be and that sort of thing. So,
and as you pointed out with the Thicke and the Pharrell lawsuit, yeah, they had access to the best lawyers to try to defend their case, but yet still also, I mean, there's still that chance of once it gets to the jury, if the jury is going to hear anything they feel similar, I don't think they're going to access too much. Was this copyrightable or not? They're just thinking, hey, it sounds the same.
Yeah, but I also think in that case, there was a couple of interesting differences, which is one, Pharrell and Thicke brought the lawsuit seeking a declaratory judgment that it wasn't copyright infringement.
Yeah, after the plaintiff, or not the plaintiff, but after the family pretty much sent him a cease and desist.
Well, that's true, but they tried to be proactive, but it kind of backfired on them. But the other thing about it too is that Marvin Gaye and, you know, now his estate is frankly larger than Thicke or Pharrell, you know, as an artist, you know, historically. So it wasn't like in this case, because a lot of trademark cases, copyright cases, the plaintiffs are usually not known or their works aren't known. So I think that plays into it somewhat as well. Like, sometimes people just think, and I'm thinking of a juror, and like maybe from a juror now. I think if you didn't have an established name or you didn't have famous works, I think it's probably tougher to convince a jury as opposed to if I'm Marvin Gaye or if I'm Beyonce and I say that person copied my song. I just think maybe it shouldn't be, but I just think it's easier. It would probably be easier to, at least when it comes to a jury, not a court.
Yeah.
But
I see it the other, I guess because I also saw the two, but I see it the other way. Sometimes when I'm looking at different works, particularly like when the whole Jay-Z came up, I mean, I'm seeing these do sound similar.
They do, but
and with Beyonce's history, she has admittedly said she goes on YouTube, she does sample other people's music, which I'm sure will be something that they bring out. And so it's not like she's going to be able to, I guess, sufficiently say, I'm always original.
Right. But I think part of my thinking might be because in this industry, to me, I mean, any work that is successful, whether it's music, a TV show, or movie, there's probably going to be a lawsuit about copyright infringement. Someone saying, you stole my song, you stole my idea. So I guess I'm a bit jaded by the fact that people, and most of them are frivolous. I mean, people just want to come up or whatever it is. But so in cases like this, where I think this plaintiff has shown a lot of detail and the similarities in the work, I really would take a lawsuit like that, very seriously. There's another one with Rihanna. I don't remember the song, but it was a video where in the video they had scenes that paralleled a photographer's work. I mean, it was like it was the same type of thing you could see side by side by side. And they ended up settling that case very quickly because when you saw the works, you're like, oh yeah, they definitely, you can see where they got that from. So again, going back to your question about should the jury decide, or is it too early for a judge to just dismiss the case now?
Has he sufficiently at least stated a claim?
Right. And I think the complaint is very, the pleadings are very detailed and they're not general on how did they get access. And I think they go beyond most lawsuits in pointing out the similarities between the works. I don't know that you have to do that at a pleading stage. But in this case, it's a good thing that they did because, you're on a motion to dismiss, so you can't really go beyond the pleadings. So they have all that for the court. So, yeah, we'll keep an eye on it and we'll give an update, as the court rules on this motion.
Well, I want to ask you one more question before we leave because obviously Beyonce has the potential to lose monetary damages just by virtue of whatever profits she gain, and that's obviously what they're asking for.
Right.
Do you think that her reputation is also going to be tarnished if this lawsuit actually goes in the plaintiff's favor?
No, I don't think so. I think, number one, I think her fans are
diehard loyal. And
they're probably mad at us for even bringing this up. But it happens all the time, so I don't think there's any stigma anymore. And she had a song. What was it? If I were a boy, or if I was a boy, something like that. And that was a copyright infringement situation as well. I think that ended up getting settled. So it's happened, and I think unless someone just blatantly rips someone off and then doesn't, they deny it or they don't want to settle with the person or give them credit or whatever, then, but I don't think the fans really care. They just want to enjoy her and her music. But, maybe some other elements of the industry might look at her differently. Yeah.
Well, and it definitely helps Mr. Matthew Fultz if he wins. Maybe now we all know who he is, and now we're sitting here talking about him. So.
Right, exactly. So,
well, thanks so much for talking about this.
Sure.
And hopefully our listeners enjoyed it as well.
Yeah.
So stay tuned for the next one, and we'll see you then.
See you next time.